Welcome back. You're watching Beyond the Headline with me, Tamanna Inamdar. The other topic we want to take up today and we think deserves a little bit of scrutiny is the fact that the sedition law and the challenge to the sedition law, which actually the petition was put in last year, is being taken up once again by the Supreme Court. Hearings will start in the first week of May and the centre has been asked to give its point of view. So it's two petitions essentially against sedition law, which is taken up by the court. A top bench, which includes the CJI, will be listening to it. And the petitions essentially challenge the validity as per the constitution of the sedition law. Now, what is the sedition law? And that's what's really important. The sedition law allows the government, the state, to actually penalize anyone who has, said anything which could harm the nation. It's a very vague definition of what the sedition law is. So it says whoever by words, either spoken or written, or by signs or by visible representation, aims to harm the state can be slapped with the sedition law. It's got a lot of parts of it which cannot be pinned down. And it has been going on for a while. Now, the sedition law is interesting because it's the favorite tool of pretty much every government in independent India, and there's no difference now. I just want to go through a brief history of the sedition law before we go any further, because it's really important to understand how long this has been hanging around. The history of the sedition law actually starts in 1275, where the offence of sedition can be traced to a statute of Westminster when the king had a divine right. By 1870, the sedition law was enacted as an amendment by the British rulers to subdue the Indian press. So that has the precedent of sedition law as far as India is concerned. In 1898, the section of sedition, which is 124A, was amended further to include life imprisonment as penalty for sedition. In 1922, Gandhiji was charged with sedition for criticizing the British who were ruling India. In 2009, interestingly, the UK has dropped its own sedition law. And it's truly a favorite. So as per NCRB data, between 2016 and 2019, the number of cases filed under the sedition law have increased by 160%. But the conviction rate is still pretty much dismal. In 2019, the conviction rate was 3.3%, which tells you that some of these cases are really not to be taken very seriously. These cases can go from, why has someone cheered for a certain country after a cricket match, to why have you politically challenged me? And it is applied quite liberally by different state governments and the central government across party lines. Now, the question is, should it be thrown out? To speak on this, I'm going to Indira Jaising, Senior Advocate. Ms. Jaising, thank you so much for joining us on the first episode of Beyond the Headline. It's truly a pleasure to speak with you today on something which we thought deserves to be scrutinized a little more closely. Do you think there's any chance this law will actually be watered down or thrown out?
Well, to begin with, in my opinion, the government of India should voluntarily repeal it in Parliament, because that would be like sending a big message to civil society that civil society will no longer be criminalized for its protest. That not being the case, the matter now will be decided by the Supreme Court of India on whether it is constitutional or unconstitutional. Now, I heard your presentation, but it's very important to reproduce the exact wording of sedition. It's not just a question of defaming the nation. This is what it says. Whoever by words or written representation, etc., attempts to bring into hatred, contempt, or exercises or excites or attempts to exercise disaffection against the government by law established in India. Now, when you say that it's vague, what it means is words and expressions like hatred, contempt, and disaffection are not defined by law. Let's begin with the expression, quote unquote, disaffection. exactly what does it mean. To a lay reader, it might mean lack of affection. But it has also been held during the colonial era in the Balgandharva Tilak case to mean disloyalty. Now, it is one thing to talk about disloyalty against a foreign power when you're seeking to attain independence. Those that fought for independence had no hesitation about being disloyal to a foreign power in order to bring about an independent nation. The question before the Supreme Court will be, once we've gained our independence and declared ourselves to be a sovereign democratic republic, how can we still accuse people of having disaffection towards the government by law established? Because that would go completely contrary to our democratic right to protest against the policies of the government. That is what happened with the CAA protesters. And it is unfortunate that in relation to the protest, they were accused not only of sedition, but also of crimes under UAPA, the law relating to terrorism. Now, if this is sufficient reason for the Supreme Court to try to strike it down, that a sovereign democratic republic cannot recognize an offense like sedition because its citizens have a right to criticize the government and its policies by lawful means. So yes, I'm looking forward to the Supreme Court striking down this law.
But ma'am, often when the sedition law is debated, the question is raised, what of treasonous activities? For example, if India is at war, and this is, the other side of the story, so to speak, and someone or an individual is acting in a way which is against the interests of the nation or at that point, what are the laws we have otherwise in our arsenal to then prosecute such a person? Is that where sedition may still be required?
Okay, it's an important question because our laws do contain crimes which are so-called against the sovereignty and integrity of India. So when you talk about a war situation, then yes, there are crimes in the Indian Penal Code, particularly known as waging war. It's still there in the Indian Penal Code, and therefore there is no lack of laws in our country which will deal with a situation where someone is attempting to wage a law against the nation or where an Indian citizen is aiding and abetting that war. There is still no need for a law relating to sedition because the situation can be dealt with. You also have the UAPA, which criminalizes the advocacy of the act of secession or secession from the territory of India. But that is very different from quote unquote disaffection against India. I don't even know what it means to have disaffection towards India, which is the expression used in the UAPA. I'd like to just point to one thing. Very often one sees the expression quote unquote anti-national being bandied about on social media, on television, in popular discourse. I would like to point out there is no crime in India known as being anti-national, except in the 1962 Defense of India rules, where there is an attempt to disrupt the military operations of India. And by the way, waging a war means that the precondition is that there has to be an enemy state declared by law to be an enemy state. Now, you can still have a civil law within the country, but again, the definition of what is a civil law is very unclear. But by no means can you conflate a riot with disaffection towards the government by law established, nor can you conflate a riot with attack on the sovereignty and integrity of India. And this is exactly what has happened in the case of the Delhi riots, in the case of Bhima Koregaon, and in many other cases. This conflation is what needs to be put an end to by the Supreme Court of India.